Roger had been serving his country in the United States military for about 10 years. He was an E6 in the military. He had been stationed overseas for the last year and a half. While he was gone, the girl he'd been sleeping with before he had left had a baby, and it was his. When he got back to the States, he was served with a paternity petition where she was asking for child support. He counterclaimed, asking for parenting time. The court heard both cases at the same time, awarded him 100 days of parenting time, and awarded her child support. Problem is the court did not award or give him credit for the time that he was going to be spending with the child. So Roger now had to pay child support going forward and was given 0 days of parenting time credit. That made Roger's child support about $200 more a month than it would have been had he gotten that 100 days credit. What the court did is it looked back over the last 52 weeks and said, you hadn't had any parenting time, we can't give you credit for it. Does that seem right? There's a common mistake that a lot of people make and a lot of lawyers make, and it's leaving the table with an agreement in substance, but not a written agreement. Imagine you're in mediation all day. You went into mediation about 9 o'clock in the morning. At 6 o'clock at night, you finally agreed on everything. You've written it out. There are handwritten notes all over the table. You're tired. You want to go home. You hadn't got time to spend another 2 hours to put the agreement that you've entered into on paper, on black and white, and sign it. So what do? You say, we'll do it tomorrow, and we'll sign it. You leave. Tomorrow happens, and guess what? Everybody's changed their mind. You don't have an agreement anymore. It's not written out. It's not signed by the parties. You got to spend that extra 2 hours in the mediation to actually write the agreement, type it up, print it off, and have everybody sign it and notarize it. That's the only way you can be sure that the settlement is final. I had a case a couple of years ago where the husband wanted a divorce, and he wanted it bad, and the wife didn't. And the reason why the wife didn't want the divorce is because she was covered on husband's health insurance. And she had some medical conditions that could have cost tens of thousands of dollars to treat without insurance. Well, she was on husband's insurance, but as soon as the divorce became final, she was going to lose that insurance. Now, she could get COBRA or extended coverage, but that was going to cost a fortune. So what did she do? She drug it out as long as she could. She refused to cooperate in mediation. She refused to answer the interrogatories that were sent to her. She drug that out. She got orders from the court that extended the time that she had to respond to certain things. And that case went on for about 2.5 years before we finally got it settled. But it took that long, and it was frustrating as heck for the husband. I had an argument in the Court of Appeals last week, and the issue before the court was whether or not the relocation of the mother with the child was in the child's best interest. The case had gone to trial some time ago, and the court had ruled that the best interest of the child will be served by allowing the mother to relocate to another city far away with the child. It was our position that it was not in the best interest of the child. You know, the law on relocation has changed in the last couple of years in Tennessee and in a lot of jurisdictions. Used to be that all the relocating parent had to show was that there was a reasonable purpose for the move or the relocation. And as long as it didn't damage the child, then the court would allow that move to take place. Now the court solely focuses on what's in the best interest of the child. Used to be the court would look at the number of days each parent spent with the child. Not anymore. The only thing the court looks at is best interest of the child.